What I want to talk about next is what types of matters does an attorney handle who is representing property owners in disputes with homeowners associations. A major part of my work is interpreting the governing documents of the association. Now, the governing documents of the association consist of a variety of documents. The one you're probably most familiar with and you get most hear about is the document called the Declaration of Conditions, Covenants, and Restrictions, which I'll refer to as the CC&Rs. But there are other documents that are also important depending on what the nature of the dispute is. The other documents could be the bylaws, the architectural guidelines, the rules and regulations, or the fine and collection policies. Now, these are some of the issues that I deal with on a regular basis concerning the CC&Rs. One major issue I frequently deal with is the subject of residential use, because most CC&Rs provide that the use in an association is limited to residential use. So the question is, what does that mean as these problems arise? So let's suppose you decide you want to save money and you close up your law office and open your law office in your house or move your law office to your house. Would that violate the residential use restriction of the CC&Rs? The answer is probably yes. Let's take another example. It starts the same way. Let's say you want to save some money. You're living in a two-story house. It's you and your spouse. You don't need a two-story house. So you decide to live on the first level of your house and rent the second level of your house out. And in addition, what you do is so that this other family can live on the second story of your house, you convert one of the bedrooms into a kitchen. So the two families can live in the house separately, one on the upstairs, one on the downstairs. Would that violate the residential restriction in the CC&Rs? And the answer is probably yes. And a case on that is Colony Hill versus Gamaty, G-H-A-M-A-T-Y, out of San Diego. Let me give you one more example. A TV producer walks into my office. It's a true story. This is actually the only time a TV producer has ever walked into my office, but it's a true story. He walked into my office and said he's having problems with his associations. I said, what's the problem? He says, well, he's filming a TV show that he's planning to promote on TV once it gets filmed. And I said, what's the TV show about? He says, well, I'm thinking of calling it Housewives of Orange County. And so I said, what's the problem? He says, the problem is I live and reside in my homeowners association, and my homeowners association won't let me film the show in the association. So I represent him, and we fight with the association for a while. By fight, I mean we send letters back and forth. That's how lawyers fight. And eventually, we work out a resolution so that my client can complete his filming of the show and then promote it to the networks. And then he, as you know, it eventually made it to TV, and then there were all these spin-off shows of Housewives of New York, Housewives of different places. And so that problem resolved itself eventually, but a major issue there was whether that was a residential use or violated the residential use restriction of the CC&Rs.